name some.
Yeas are 325. The nays are 101. The amendment is adopted. There being no further amendments under the rules, the committee rises.
The Chairman of the Committee of the Whole House on the State of the Union reports the committee has had under consideration the bill H.R. 3685 and pursuant to House Resolution 7093 reports the bill back to the House with sundry amendments adopted in the Committee of the Whole. Under the rule, the previous question is ordered and a separate vote demanded on any amendment reported from the Committee of the Whole. If not, the Chair will put them in gross. The question is on adoption of the amendments. Those in favor, please say aye. Those opposed, please say no. The ayes have it. The amendments are adopted. The question is on engrossment and third reading of the bill. Those in favor, please say aye. Those opposed, please say no. The ayes have it. Third reading.
A bill to prohibit employment discrimination on the basis of sexual orientation.
You cannot hear anything.
The gentleman is correct. We're at the beginning of a long evening, and the sooner the evening begins, the sooner we can complete our business. Purposes, the gentleman from Virginia rise.
Mr. Speaker, I have a motion to recommit at the desk.
Is the gentleman opposed to the bill?
I am in its present form.
The gentleman qualifies. The clerk will report the motion.
Mr. Forbes of Virginia moves to recommit the bill H.R. 3685 to the Committee on Education and Labor with instructions to report the same back to the House promptly with the following amendment. In Section 8C as amended, strike as used in and insert the following.
Members of the House are advised that members are desiring to hear the reading of this motion. Please take your conversations off the floor. Clerk will read.
In Section 8C as amended, strike as used in and insert the following. 1. As used in. At the end of Section 8C as amended, insert the following. 2. Nothing in this act may be construed to modify, limit, restrict, or in any way overturn any state or federal definition of marriage as between one man and one woman, including the use of this act as a legal predicate in litigation on the issue of marriage.
Mr. Speaker, I offer this
In order. The gentleman is entitled to be heard.
The gentleman is correct. Members will please take their conversations off the floor. Members who are clustered in the aisles and having conversations will please take themselves and their conversations off the floor.
Mr. Speaker, I offer this motion.
5 minutes.
Thank you, Mr. Speaker. Mr. Speaker, one of the big concerns that many of us have with legislation of this type is that courts across the country have used it to establish public policy, and then certain judges have taken that and determined from that public policy that they're going to redefine the institution of marriage. And in considering this bill, I'm deeply troubled not only by what's in the bill, but where I believe this bill is leading us, and you don't have to take my word for it. A memo from the Marriage Law Project at Catholic University's Columbus School of Law noted this, quote, ENDA is about more than jobs. It's also about marriage. ENDA is based on the idea that state laws restricting marriage to the union of one man and one woman are a subterfuge for discrimination against homosexuals and bisexuals. If the courts accept the proposition that marriage is a subterfuge for discrimination on the basis of sexual orientation, the Defense of Marriage Act will be struck down as unconstitutional. And that is the goal, Mr. Speaker. This legislation will ultimately allow activist judges across the country to redefine the institution of marriage. Now, the majority might say that's not their intent, but I guarantee that's exactly what will happen if ENDA passes as it is. If we don't vote to stop it, then we are tacitly allowing one of our most sacred institutions to be torn down. This legislation will provide certain activist judges with the legal justification to strike down state and federal marriage laws that define marriages between one man and one woman. State ENDA laws are being used by activist judges to impose same-sex marriage and civil unions on states. State courts are using ENDA and other similar laws to justify the argument that the government has no rational basis to continue discriminating in the area of marriage. And this is not something that might happen down the road. It's already happened in 3 states, Massachusetts, Vermont, and New Jersey. In Massachusetts, the Supreme Court there decided in Goodrich versus Department of Public Health that there was no rational basis for the denial of marriage to same-sex couples.
And members and staff will take their conversations off the floor. Members and staff in the aisles will please find seats or take off the floor. Gentleman from Virginia.
Thank you, Mr. Speaker. In that case, the court cited a list of state statutes, including non-discrimination laws, as evidence that the state should not discriminate in the area of marriage. The court's opinion laid it out clearly, writing, quote, Massachusetts has a strong affirmative policy of preventing discrimination on the basis of sexual orientation. You can't get any clearer than that on how non-discrimination laws can be used to undermine marriage. However, even before the Massachusetts decision, the Supreme Court of Vermont in 1999 ordered the state legislature to pass either a same-sex marriage or civil union law. The Vermont court relied in part on the fact that the state had a law preventing discrimination based on sexual orientation. The court said it would be irrational and thus not meet the rational basis test to argue that the state could refuse to allow same-sex marriage or civil unions when they clearly already had a law prohibiting discrimination on the basis of sexual orientation. And most recently, New Jersey's courts have gotten into the game. In 2006, the New Jersey Supreme Court gave the state legislature 6 months to pass either a same-sex marriage law or a civil union law. In Lewis versus Harris, the court stated, New Jersey's legislature has been at the forefront of combating sexual orientation discrimination and advancing equality of treatment towards gays and lesbians. In 1992, through an amendment to the law against discrimination, New Jersey became the 5th state in the nation to prohibit discrimination on the basis of affectional or sexual orientation. Mr. Speaker, I rise today to ensure that this bill does not become the building block that some may want to use to destroy the institution of marriage. The motion simply says this, that nothing in this act can be used to construed to modify, limit, restrict, or in any way overturn any state or federal definition of marriage as between one man and one woman, including the use of this act as a legal predicate in litigation on the issue of marriage. On the wall in my office, I have a framed copy of the Declaration of Independence and the pictures of our founding fathers. This wall serves as a reminder of me of the ideals and institutions our country was founded on. Yet every day we see people trying to rewrite our history and tear down those ideals and institutions. This country is great because of the ideals of our founding fathers, but eventually if we chip away at enough of our values, we'll lose our foundation. This is what's happening and will continue to happen unless we stand up and make sure it doesn't. Marriage between a man and woman has been the cornerstone of strength in our country, and while it may be under attack from all sides, I believe it's an institution worth protecting. This motion allows us to take a stand for marriage for our country, and at least for today puts a stop to those that are trying or may try to use this legislation as a predicate to change those laws. This motion would ensure that the intention of this Congress are clear and unambiguous.
Gentleman's time has expired.
I yield back the balance of my
Gentleman's time
time.
has expired. Purpose, the gentleman from Massachusetts rise. Is the gentleman opposed to the motion? I am. The gentleman is recognized for 5 minutes.
Before I begin, I have an inquiry. Would the gentleman from Virginia, the proponent of the motion, yield to me for a unanimous consent request to change this to a motion of forthwith so the House could simply adopt this forthwith and go to dinner?
I would object.
Well, this is now clear. This is a motion to do this promptly. Promptly means at the speediest 9 calendar days, because it does not, as the parliamentarian has informed us in writing, waive any of the rules for committee meetings, for Rules Committee, etc. So the purpose here is the intent perhaps not the purpose, but the unmistakable intent would be to put this off until after we are due to adjourn November 16th. And for what purpose? For the purpose of restating what has already been stated. It is interesting, Mr. Speaker, and I take some encouragement from this, that opponents of the principle of non-discrimination don't want to debate it on its merits. We haven't heard any defense of discrimination. We just have a parliamentary maneuver to protect it. This is not about marriage. In fact, this is not a recommit, it's a statement. It says, nothing in this act may be construed. Correct. No one who reads English could think to the contrary. But just to make sure, the gentleman from California offered a motion, and the minority tried not to have it be roll called, and you voted for it, members of the House, and it says, as used in this act, the terms married or marry refer to marriage as defined in Title 7, Section 7, Title 1 of the U.S. Code, the Defense of Marriage Act. The members of the House just voted overwhelmingly to reaffirm that definition. So what do we have? A motion now simply to delay by reaffirming the last vote. And the gentleman from Indiana thought there was some other language that might lead to a marriage problem. So we adopted that. So this is the third effort to say the same thing. Not to say the same thing, but to defeat it. And I would say this, I would recommend to my friend from California who's done such a good job on this, once we have concluded this, report this out as a separate bill, this third reiteration, if it gives people some comfort. Because we are talking now, and I asked the gentleman to make it forthwith. If there was a real need to do this, it would be now part of the law and we would be voting. It is promptly because it adds nothing to the bill, nothing, literally nothing. It subtracts nothing. It's simply a motion to delay. And I now want to address that. I want to address the motion to delay. Mr. Speaker, we say here that we don't take things personally, and usually that's true. Members, Mr. Speaker, will have to forgive me. I take it a little personally. 35 years ago, I filed a bill to try to get rid of discrimination based on sexual orientation. As we sit here today, there are millions of Americans in states where this is not the law. By the way, 19 states have such a law. In no case has it led to that decision. The Massachusetts law passed in 1989 that did not lead to the decision in 2004. Unrelated, but here's the deal. I used to be someone subject to this prejudice, and through luck, circumstance, I got to be a big shot. I'm now above that prejudice. But I feel an obligation to 15-year-olds dreading to go to school because of the torments, to people afraid they'll lose their job in a gas station if someone finds out who they love. I feel an obligation to use the status I have been lucky enough to get to help them. And I want to ask my colleagues here, Mr. Speaker, on a personal basis, please don't fall for this sham. Don't send me out of here having failed to help those people. We have already today twice voted overwhelmingly to repudiate any suggestion that this had anything to do with marriage. What you have is a ploy by people who want to keep discrimination on the books, who want to deny protection to so many vulnerable victims of discrimination, but they at least understand that that's not something you can say explicitly. So they give us this sham. I ask again, would the gentleman allow us to adopt this forthwith? Would the gentleman yield to that purpose so we can make this forthwith?
I'll be glad if the gentleman would yield me some time.
No, I asked the gentleman a simple
If the gentleman don't want me to respond, then I won't.
No, yes, the response is no. I'm ready to yield to make this forthwith, so this extra language, which does nothing, can be added. But if you don't do that, as they won't, and you vote for this, you're killing this bill. Understand that. 9 days later, it's too late for this bill, and we're out of this. So I will close with this plea. Yeah, this is personal. There are people who are your fellow citizens being discriminated against. We have a simple bill that says you can go to work and be judged on how you work and not be penalized. Please don't turn your back on them.
Gentleman's time expired. Objection. The previous questions. Without objection, the previous question is ordered on the motion to recommit. The question is on the motion to recommit. Those in favor, please say aye. Those opposed, please say no. In the opinion of the chair, the noes have it.
I ask for the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise. A sufficient number having risen, the yeas and nays are ordered. Members will record their votes by electronic device. Pursuant to Clause 8 and Clause 9 of Rule 20, this 15-minute vote on the motion to recommit will be followed by a 5-minute vote on passage of the bill if ordered and suspension of the rules and adoption of House Concurrent Resolution 236. This is a 15-minute vote.
This is a procedural vote to the workplace discrimination bill that would send the legislation back to committee. When Democrats took control of the House in 2006, they said they'd pass a bill that would protect gays, lesbians, bisexual, and transgendered people from workplace discrimination. This debate and vote today is fulfilling that promise, although transgender people are not included in the legislation. President Bush has threatened to veto the bill, and a statement from the administration saying that legislation would make interpretation, compliance, and enforcement extremely difficult, and that it is virtually certain to encourage burdensome litigation beyond the cases that the bill is intended to reach. We've been watching French President Nicolas Sarkozy speak before a joint meeting of Congress today. Associated Press saying that President Sarkozy came to Washington